Hello everyone, I'm George. So I'm going to continue where I left off yesterday in my introduction to the evolution of English law, and I was just talking about equity, the Court of Chancery and so forth. So I'm going to start today with how equity collided with common law and how this situation was resolved. The two systems obviously existed in parallel, cross over with each other. It was very complicated, and sometimes they bumped into each other. So how was the situation dealt with? Because this was due to the king being the source of this system of equity. The Lord Chancellor at the outset of the 17th century was Lord Ellesmere, and he usually said that any critique of the current system was lèse majesté, and you can't insult the monarchy. And so people would usually back down at that point. So the rulings of the Court of Chancery were not directly enforceable. So how were you going to enforce them? Well, that was simply by sequestering the property of anyone who didn't abide by the rulings. You could also incarcerate people. So there was a row between the two systems, equity and law. So common law judges said that anyone who opposed their efforts to enforce their rulings was committing a grave crime, and so one chancery officer who tried to carry out one of these orders was killed. But was that acceptable? Well, a court ruled that it was permissible self-defense. So when this dispute got to its worst, Lord Ellesmere had irritated the common law judges by listening to cases which should have been before them in the Court of Chancery. And the common law courts had already dealt with the issue. So this was ridiculous. It couldn't go on where there were two parallel systems contradicting each other, and it wasn't clear which one took precedence or what was the line between them, what was the border. So to delineate what really is dealt with by the common law courts and which ones by the Court of Chancery. So there was the Chief Justice of the King's Bench, Lord Coke, or Lord Cook, as some people pronounce it, in the early 17th century. A great jurist. You should see that pub on Chancery Lane where there's a portrait of him. So he hit back, and he ordered that certain prisoners be set at liberty who'd been sent to prison by Lord Ellesmere for not abiding by injunctions. And then Lord Cook, or Coke, is spelt Coke, urged them to bring a case against those who'd locked them up, claiming that it was for false imprisonment. They had impeached the judgments of the King's courts by going to the Court of Chancery. Anyway, it didn't work for one litigant who tried to indict the Lord Chancellor. So James I had to adjudicate all this. There was the celebrated Lord Oxford's case of 1615. James I had to rule on this, and he said when the two systems came into conflict, equity would take priority over common law. And so this was later put into a statute, the famous Judicature Acts of 1873 to 75. And it's now part of the Supreme Court Act 1981. But people were still treading on each other's territory, particularly on the rulings of the common law courts. The Court of Chancery had to limit itself and rule only according to precedents about what was considered chancery. So this dampened down the criticism of equity. People said, well, it's just up to the whim of the individual judge. So the situation was rendered a bit more tranquil when Lord Ellesmere died in 1616. So he was the major disputant on his side of the debate. And the next Lord Chancellor strove to establish more cordial relations with the other side. So like two halves of the judiciary at war against each other, not quite literally. So this dual system in English law was set up in 1615. English law has got common law, and there are rules of equity which are really part of that, so they're no longer at loggerheads as they were in the early 17th century. Prior to 1875, the system was characterized by having one court, the Court of Chancery, which is the only one to apply it. So the two systems created various complications for litigants. In the beginning, an equitable remedy such as damages was required, and then you would need to move two actions. One under the system of common law and a second one in Chancery. Remember, Chancery is mainly to do with documents. They're Chancery barristers to this day, which are thought to be terribly intellectual. So the Common Law Procedure Act in 1875 said that common law courts were empowered to grant equitable remedies. So a remedy is something to put it right. The Chancery Amendment Act in 1858 granted the Court of Chancery the legal power to give damages in lieu of an equitable remedy. In lieu meaning in place of, in case there is no equitable remedy. But the situation was still not quite sorted out. So let's look at how it moved from 1838 onwards. Well, in the Judicature Acts 1873 to 75, these abolished the separation of three different courts, common law courts, and the Court of Chancery. It created one High Court and a Court of Appeal, which could apply common law and equity as well, so that we achieved fusion of the two systems. But if the two collide, equity takes precedence. Anyway, so the two systems were amalgamated. The distinction between common law legal rights and indeed equitable rights, or we sometimes say beneficial rights, still remains, and it's particularly pertinent to the law of property. So equitable remedies are at the discretion of the bench. That means the judges. We say they're sitting on the bench, whereas common law damages are your right, and they're not discretionary. That's not up to the fiat of the beak on the bench. So in the 19th century, there were further reforms, but they were not as extensive as in prior centuries. So the whole system had to be updated, rationalized. The writ system as existed was abolished. There still are writs, but it's a different meaning from the original idea of a writ. So local courts were largely done away with because they had been very pricey for litigants, and they were very slow in handling even minor claims. I can't remember who said it. You have to spend £100 to recover 10. So how were they going to sort out this vacuum which had been created? The County Courts Act in 1846 started to do just that, and hundreds of county courts were set up. So they couldn't handle cases worth more than £20. Although £20 was some considerable sum of money in the mid-19th century, you can put two noughts on the end of that. Now in the 20th century, there were more efforts to bring things up to date and to speed up the whole system. The Courts Act particular of 1971 in particular, I've mentioned it already. So this did away with the last few local courts, and the Act set up a Crown Court in various places around England and Wales, and finally spelt finis for the assize system. So let's look at some of the legislation now. In the 19th century, there was a lot more legislation. Up until the 19th century, there had been actually very little legislation. Remember, until the end of the 17th century, Parliament sat only occasionally, might sit for just a couple of months out of 10 years. But society had moved on, and there was a great deal of secondary legislation. The state took it upon itself to regulate all sorts of areas of life. Remember, 200 years ago, there were no health and safety laws, and the ordinary person had very, very few rights. You weren't to be imprisoned or executed unless you're proven guilty of a crime, really, you could speak your mind up to a point, not criticize Christianity, but you had no sort of guarantee of health and safety at work, or if a breach of contract, if you were the employee, you could do very little about that. Or if you broke the contract as an employee, that was a crime. Whereas if the employer or master, as they said in those days, broke the contract, that was a civil matter. So the courts were not class neutral. The law was very much slanted in favour of the wealthy, because those who have the gold make the rules, as that's the Murphy's law, not a real law, but he described what the situation was. The establishment suited themselves. But the 19th centuries began to change, and that required a great deal more legislative intervention. So tribunals were set up, all sorts of quasi-judicial bodies, such as the Social Security Appeals Tribunal, Employment Appeals Tribunal, industrial tribunals, and so forth. Parliament asserted its legislative supremacy. It is the paramount lawmaking body in the United Kingdom, so it's known as parliamentary sovereignty. Anyway, so you ought to read the work of Albert Venn Dicey, who was Vinerian Professor of Public Law at the University of Oxford in the late 19th century, right up until his death in 1920. And his most celebrated work is An Introduction to the Study of the Law of the Constitution, which he published in 1885. So Professor Dicey, as he's never known, said that parliamentary sovereignty is that the English Constitution gives it the right to make or unmake any law at all, and that nobody has the right to override what Parliament says or does. And that's it. And that is absolutely central to the British Constitution. But the British Constitution is kind of another matter. What is it? It's a smorgasbord. It's very difficult to define, and it's questionable which documents form part of it. That was Dicey's view. All sorts of fabulous things about Dicey, but Dicey had his flaws. He was openly racist. He was a man of his time. So we might say we find his racial views rebarbative, but that doesn't mean that his description of the Constitution was wrong, or indeed that it was right. So there was a leading case, which is British Railways Board and Picken in 1974. The case was about who owned the land over which the railway ran, and the railway line had been abandoned because of the beaching cuts in the early 60s. They're no longer running trains down there. They might have even taken away the rails and the wooden sleepers. So what should happen to it? So the owners of the land on either side of it, should they get the land? But an Act of Parliament said that the land would be owned by the British Railways Board, even though no trains were being operated there. Picken, who owned the land next door, said this is wrong because the British Railways Board had lied to Parliament, and so Parliament's own procedure hadn't been adhered to in passing the legislation. So the House of Lords, only the judges in the House of Lords, not all 800 doddering peers, ruled that the courts are not entitled to look at parliamentary procedure and see whether it's been abided by or not. And the courts, they are subordinate to Parliament, they're not superordinate, and so the courts have no legal power to declare an Act of Parliament struck down, and that's different in many other legislations, including the Republic of Ireland, for example. So onto the European Communities Act of 1972. Edward Heath, the Conservative Prime Minister, was hell-bent on leading the United Kingdom into the European Economic Community, as it then was, or the Common Market, as it was commonly called, that later morphed into the European Union. So he signed the Treaty of Rome, and he had a Parliament pass the Act of Accession, so that was ratifying it, and then passed the European Communities Act in 1972, setting the case for the UK to join the EEC on New Year's Day, 1973. So this was a seminal moment in British history, and particularly pertinent to legal history. So many issues would be dealt with by the European Union, or EEC as it was back then. What areas would be in the purview of the EU is debatable, but Heath assured people there would be no loss of essential national sovereignty. That's a direct quotation. No loss of essential national sovereignty. Now, essential is the operative word. What's essential? So there would be some, but be inessential sovereignty. But his own civil servants had actually told him in confidential memoranda that that wasn't the case, that there would be. Maybe loss is too negative a word. It might be pooling of sovereignty. Fine. But he was still misleading the public. You might be a Europhile. You might think the EEC was a splendid thing. Perhaps it was, but he wasn't entirely straight. So one of the core principles of the EU law is that EU law is supreme over the laws of all member states. And when the UK joined, there were 12 countries in the EEC. So EEC later became the EU. The European Economic Community required that courts in each member state, including the United Kingdom, must uphold the rights which are enshrined in EU law. And there's some of these laws have direct effect. They have to interpret national law in a manner which is compatible with European law insofar as it's possible to do so. This is called indirect effect. So at the moment, we're not quite sure what the situation is. It's a ball in the air. So we know the UK has just left the European Union, but so when we outside the ruling of the European Court of Justice, or as we're encouraged to call it, the Court of Justice of the European Union, which meets in Strasbourg, right? So there's a very complicated situation here. There's the European Court of Human Rights. Sorry, what am I saying? The European Court of Justice is in Luxembourg. The European Court of Human Rights is in Strasbourg. They're very often mixed up. Okay, the European Court of Human Rights is not a European Union court. I'll say it again. The European Court of Human Rights is not a branch of the European Union. Okay, it's to adjudicate matters pertaining to the European Convention on Human Rights, which was written in 1948, and about 45 countries are signatories of that, including Russia, as in including many countries which are not in the EU. Now, having said that, the European Court of Justice and the European Court of Human Rights don't have an antagonistic relationship. The judges, they regularly speak to each other. They're very open about this. They learn from each other. But the European Court of Justice is an EU court to adjudicate disputes between the member states, a member state and the EU itself, or different bodies within the EU. Whereas the European Court of Rights is something different. It's about the European Convention on Human Rights. Having said that, all member states of the EU have to domesticate the European Convention on Human Rights. All right. So anyway, so EU law is still going to be pertinent to the United Kingdom, particularly in regard to trade, because the United Kingdom still wants access to the internal market, even if it doesn't have full access to that. Some matters to do with the EU will be dealt with by the European Court of Justice. Obviously, but there'll be no British judges on it. Nevertheless, the judges there are to act in an impartial manner and not be biased towards their own member state. So let's look at the Human Rights Act passed in 1998, which took effect in 2000. And that was the one which put the European Convention on Human Rights into domestic British law. And so many people thought that was a great step forward. Okay, so that's just a very little bit to finish off some aspects of this introduction to the evolution of the law of England and Wales. Toodaloo.